Hello everyone. So, somewhat strange circumstances. I'm pre-recording this in my dining room. My name's Jenny Smith and I'm a partner at Harper Macleod. I obviously won't be available for questions, but the text of my talk should be with you and it's got my contact details. So I'm going to speak today about domestic abuse. It's something that's always been a feature of the work that family law professionals encounter. However, lockdown and self-isolation during the pandemic has brought it into sharp relief as victims have been forced to spend lengthy periods of time with their abusers. I've seen an increase in enquiries and so have colleagues, and I suspect we probably will see more as lockdown continues to be eased. Statistics have shown that for China, which obviously is further ahead of us in terms of the pandemic, there's been a dramatic rise in domestic abuse. There's obviously criminal sanctions, but there's steps that we can take in the civil court too. My talk is going to start by looking at what constitutes domestic abuse so far as family law practitioners are concerned. I'll give an overview of the 5 main pieces of legislation which cover domestic abuse, and I'll then go on to look at the various protective orders which family law professionals can obtain. Finally, I'll look at the practical aspects involved for us in advising and acting for clients regarding domestic abuse and protective orders. And I have to say my thanks go to Neil Hay, solicitor advocate. He's at MTM Criminal Defence Lawyers. He's let me use part of a talk that he gave to our family team at Harper Macleod recently in relation to the definition of domestic abuse and the key legislation so far as criminal practitioners are concerned, so those 5 key pieces I mentioned just earlier. So, first off, basics. How do we as family law practitioners recognise domestic abuse? The term domestic abuse is given to describe a form of inappropriate behaviour between 2 individuals who are or may have been in a relationship with one another. There is a misconception that domestic abuse only involves physical harm being inflicted on one person by another, but in fact it can take several forms, including physical, sexual, mental, emotional abuse. Abuse is legally defined as violence, harassment, threatening conduct, and any other conduct giving rise to physical or mental injury, fear, alarm, or distress. Conduct can include speech and mere presence in a specific location. So it's absolutely not just physical abuse that we can help with. What type of behaviour is considered abusive? And again, it's not just the obvious someone being hit or physically abused. It's usually, though, a persistent and controlling behaviour causing physical or emotional harm. Unfortunately, the longer the domestic abuse persists, the more severe the behaviour can become from time to time. More specifically, it includes behaviour which is violent, threatening or intimidating, and behaviour that's designed to have one or more of the following effects on a victim, or would be considered to have that effect by a reasonable person. So, firstly, making them dependent on or subordinate to the perpetrator, then isolating them from their friends, relatives or other sources of support, controlling, regulating or monitoring their day-to-day activities, depriving them of or restricting their freedom of action, frightening, humiliating, degrading or punishing. So the above could, for example, include preventing the victim having access to money, being very controlling financially, or from having access to their phone taken away, or from other forms of communication. It could include controlling the victim's movements, abusive name-calling, playing mind games that cause them to doubt their sanity. There was a lot when the Domestic Abuse Act came out about coercive control, and I suppose what I've just described falls into that category. So, complaints can be made to the police and they'll investigate matters. Often abusers will be charged and then subject to bail conditions preventing them from approaching the victim. And I always tell anyone who's a victim of domestic abuse that first and foremost, the police should be their port of call first. The police can take immediate action, immediate intervention steps to protect the client and their family in a way that we as family practitioners, with the best will in the world, we can't. So I say dial 101 if it's not an emergency, and then 999 if it is an emergency. I've put into the text of the talk a link where more information can be found from the Police Scotland website. Police Scotland and the Crown Office and Procurator Fiscal Service have adopted a common definition of domestic abuse, and that's useful for us to be aware of as well. It applies to anyone who's ever been in a relationship, applying equally to males and females. So it covers married, cohabiting, separated or divorced, boyfriend, girlfriend, heterosexual or same-sex and LGBTI couples. The definition is physical abuse, aggressive or threatening behaviour, sexual abuse, psychological abuse, mental or emotional abuse within the context of a relationship between a partner or a former partner. So it's wide. There's a joint protocol between Police Scotland and COPFS which applies principles which are to be applied to all domestic allegations. And those are: arrest the suspect, presumption in favour of prosecution, bail opposed or special bail conditions, complainer's support for prosecution not required, counter-complaint may not be investigated, so the police will decide who is the principal perpetrator. The 5 pieces of legislation from the criminal perspective is what I'm going to come on to now, and I'm not obviously going into the detail of them because that's out with my area of expertise. The first one is the Communications Act 2003, and this defines offensive communication as sending a message that is grossly offensive or of an indecent or obscene or menacing character over a public electronic communications network. That's section 127 of that Act. So this would cover texts, voicemails, that kind of communication. The second piece of legislation is the Sexual Offences Scotland Act 2009. This codified sexual crime in Scotland, reworked the law of consent. There cannot be consent where there is no free agreement, and it introduced new crimes such as voyeurism. The third piece of legislation is the Criminal Justice and Licensing Scotland Act 2010. This brought in the domestic breach of the peace under section 38. Offences are committed if a person behaves in a threatening manner, which behaviour is likely to cause a reasonable person to suffer fear or alarm, and the person intends by the behaviour to cause fear or alarm, or is reckless as to whether the behaviour would cause fear or alarm. This offence can be committed in private, although corroboration is still required, but that could be, for example, by way of a phone recording or neighbours calling the police due to a disturbance. This Act also brought in the offence of stalking under section 39, and that's a course of conduct with the intention of causing the other person fear or alarm. Section 29 lists what is meant by conduct, and it includes following someone, contacting or attempting to contact someone by any means, monitoring someone's use of the internet, email or other electronic communication, watching or spying on someone, and as a broad catch-all, acting in any other way that a reasonable person would expect the other person to suffer fear or alarm. So we commonly encounter that where we have clients who come to us to say a relationship has ended and the former partner won't accept it, for instance turning up at their place of work or a house, or trying to stop them on social media. The fourth piece of legislation is the Abusive Behaviour and Sexual Harm Scotland Act 2016, and this refers at section 1 to the domestic aggravation. Revenge porn is dealt with at section 2 and non-harassment orders at section 5. Revenge porn would include, for example, using intimate photos obtained during the relationship and then publishing them, for example, sent in text messages or put on social media. So I've had cases where Facebook has been used to put up images that the former partner would not have wanted to have been put up. In relation to non-harassment orders, the legislation now provides that at the sentencing stage and at disposal by the court stage, where it is deemed to be domestically aggravated, the court must consider a non-harassment order. And what that means is the accused faces not only traditional sentencing, such as jail or financial penalty, but also a non-harassment order. The fifth and final piece of legislation I'll mention in terms of the criminal sphere is the Domestic Abuse Scotland Act 2018. Section 1 of the Domestic Abuse Scotland Act 2018 defines the offence of a course of abusive behaviour towards a partner or ex-partner which the reasonable person would consider likely to cause the partner or ex-partner physical or psychological harm, committed either intentionally or recklessly. Section 2 elaborates on what is meant by abusive behaviour. It includes violent, threatening or intimidating behaviour, including sexual violence. Effects of the behaviour are listed too, including making the other person dependent or subordinate, isolating them from friends, relatives or sources of support, controlling, regulating or monitoring day-to-day activities, depriving or restricting freedom of action, and frightening, humiliating, degrading or punishing the other person. As with all criminal offences, the standard of proof for an individual to be convicted of the offence is beyond reasonable doubt. Section 5 of the Domestic Abuse Act 2018 creates an aggravation to an offence under Section 1 by reason of involving a child under the age of 18. An aggravation means that the court ought to treat the offence more seriously upon conviction. The aggravation is proved if the Crown leaves evidence which need not be corroborated to show that in the commission of the offence, the perpetrator of domestic abuse either directs behaviour at a child, makes use of a child in directing abusive behaviour at their partner or ex-partner, if a child sees, hears or is present during an incident of abusive behaviour, or if a reasonable person would consider that the abusive behaviour would likely adversely affect a child usually residing with the accused or complainer. The court requires to recognise the aggravation, record it and take the aggravation into account when determining the appropriate sentence. And you can see how this starts to impact on our jobs, because if you imagine you're acting for someone who has been convicted and is trying to get contact with the child of the relationship, you can see how that will be much more of an uphill struggle for him or her. I'm grateful to Neil Hay for the following statistic. The Scottish Police Authority's statistics for the first year of operation of this Act detailed 1,700 reports of crimes. So it's clearly uncovering a pretty significant volume of incidents, and I have had several cases where the clients have said to me that there is certainly pending proceedings under this Act. Neil explained there have not actually been many prosecutions yet, and that's apparently because it takes so much time to gather the evidence, and of course we've got the impact of the pandemic on slowing things down and on court business. We're family law professionals, not fiscals or criminal lawyers, but I think it's useful to know a bit about the criminal sanctions. Often victims of abuse will come to us after the police have charged the other person, and of course, as well as acting for victims of domestic abuse, we act for those accused of domestic abuse crimes. It's good if we do have some understanding and knowledge of these criminal aspects. And also we're relevant to be able to point our clients in the direction of a good criminal lawyer. Okay, so enough of the criminal side. Turning now to what can the civil courts do to protect our clients from domestic abuse. If the police have insufficient evidence to charge an abuser with a criminal offence, it doesn't, of course, prevent victims from seeking protection through the civil courts. With assistance from a family lawyer, the law in Scotland offers a number of remedies by way of court orders to victims of domestic abuse to protect them or their children from the future risk of abuse. So I'm going to go through the protective orders which we have available to us here in Scotland. So, first off, exclusion orders. Once granted, that suspends the occupancy rights of the abuser and thereafter prevents them from coming to live in the family home, despite their ordinarily having occupancy rights to live in the property if they wish to do so. So, for example, if it's a spouse or if it's a joint owner or indeed a sole owner. Spouses and civil partners automatically have occupancy rights regardless of whether they're a title holder or not. An exclusion order, in order to be effective, has to be combined with other orders, including a warrant for summary ejection and an interdict preventing the abuser from entering or remaining in the property. It's obviously a draconian remedy because it deprives someone of the right to live in their property. So in seeking the order, it's important that we're as well prepared as possible, and I will cover that later on in this talk. Next up, common law interdicts. So an interdict is an order whereby the court stipulates that an individual is to refrain from carrying out a specified action or behaviour. For example, a victim of domestic abuse could ask the court to interdict their partner from approaching them or coming within a certain distance of the family home. Powers of arrest. A power of arrest is an order that's usually sought together with interdicts and exclusion order. You wouldn't get it at a pre-service hearing, but the benefit in obtaining a power of arrest is that it will result in the police being able to automatically arrest an individual if they've breached the terms of the protective remedy which has been granted. Matrimonial interdicts. They're interdicts that restrain or prohibit conduct of one spouse towards the other spouse or a child of the family. So that might include prohibiting a spouse from entering the family home or any other residence of the victim's place of work, or any school the child might attend. Now, you've probably heard also the term domestic interdict, and that's effectively the same as a matrimonial interdict, but it applies to two people who might be living together or were living together as cohabitants, so not married. Then we have non-harassment orders, and I want to talk a wee bit more about this type of order because it's a little bit more unusual in the sense we don't often ask for them, but actually I think it's something that maybe we could be using more. It's designed to protect a victim from a course of conduct which amounts to harassment and causes the victim alarm and distress. So that would include, for example, frequent phone calls or repeated text or social media messages. The benefit of a breach of a non-harassment order in the sense of protection for the victim is it's a criminal offence, so it can result in a monetary fine or imprisonment. So it's perhaps more of a deterrent for an abuser. Section 8 of the Protection from Harassment Act 1997 outlines the law in Scotland. I mentioned the later act, which also covers partly to do with harassment, but the 1997 Act is the start point. So it provides that every individual has a right to be free from harassment. It confirms that a person must not pursue a course of conduct which amounts to harassment of another person and is intended to amount to harassment of that person, or occurs in circumstances where it would appear to a reasonable person that it would amount to harassment of that person. Harassment in the context of family law most often relates to separating spouses or cohabiting couples who have separated. However, in some circumstances, harassing behaviour can arise from third parties, such as new partners or family members. It can also be a form of domestic abuse. How do we define harassment and a course of conduct? For example, if we have a client who comes to us and says, I split up from my partner last week and he has been bombarding me with phone calls ever since. Is that enough for us to say, hand on heart to this person, yes, we can apply to court for non-harassment order? Harassment of a person includes causing the person alarm or distress. Conduct is the actions taken by a person to cause another person to feel alarmed or distressed. Conduct may include speech or such other actions amounting to a course of conduct occurring at least 2 occasions. So examples of harassing behaviours might include text messages, repeated phone calls, stalking, unwanted letters, emails or visits from a person, posting messages using social media about them, threatening and abusive behaviour, cyberbullying, for example via Facebook or Twitter, Snapchat and all the social media forums, spreading rumours, blackmailing. So it's a really wide list, and it's all the things that one could imagine doing if one had, I suppose, been dumped, for want of a better word. And I think back to how I behaved when I was younger, and wonder if maybe now there would be something that could be said for harassment order against me. If somebody came to me and they'd split up a week ago with somebody and they were getting a lot of text messages from them, but that was it, I probably wouldn't be saying to them to go straight to court because it's really expensive. It would depend on the tenor of the text. But I suppose in that situation I'd be tempted to send a letter to the person who was sending the messages first, asking them to cease and desist. But you have to do it on a case-by-case basis, and you can never be too, what's the word, you shouldn't be blasé about domestic abuse. Certain types of behaviour of a harassing nature also have specific areas of law relevant to deal with harassing behaviours towards them, such as race, disability, religion, gender or sexual orientation, and I'm not going to cover that, but just to be aware of it. So, what is a non-harassment order? It's designed to protect the victim from a course of conduct which amounts to harassment and causes the victim fear, alarm and distress. In some circumstances, as I've mentioned earlier, where a person's been convicted of a criminal offence, the court may also grant a non-harassment order against that person. In those circumstances, as distinct from when we're acting, the order would be applied for by the Procurator Fiscal, requiring the offender to refrain from the conduct as specified in the order. A non-harassment order will not be granted unless the defender has been given an opportunity to be heard in court. As a result, in common practice, it's usual to apply for an interim interdict order to be granted at the pre-service hearing until such time as the defender has had the opportunity to be heard and a non-harassment order has been granted. So how does the court decide whether to grant the interim interdict or instead a non-harassment order? Basically, it's more to do with the test for each of these offences. It very much for a non-harassment order, it's determined on the balance of probability. So, is it more likely than not? And the order is appropriate to prevent the abuser from further harassment of the victim. Conversely, for interim interdict, the court makes the decision on the balance of convenience. How do we defend a non-harassment order being granted against our client? We can defend it if we can show that the course of conduct complained of was authorised under any rule of law, was pursued for the purpose of preventing or detecting crime, or was reasonable in the particular circumstances. So, for example, your client might say, well, I know I was close to her street, but I have a new job and my job involves going through that area. That's not a very good example, I've just made it up there, but that might be a way forward as a defence. If the order has been granted against a client, it is possible to apply to the court to seek variation of or revocation of the order, but again that's a balancing act because there's obviously the cost of applying to court. What happens if someone does breach a non-harassment order? It's important that if a person has breached the non-harassment order, that's reported to the police. The police may then charge the person, and the matter will be considered by the Procurator Fiscal on whether the person will be prosecuted. Evidence may be required to demonstrate that the breach of the order took place. It is a criminal offence, so it can result in the person being sentenced with a fine or imprisonment. In addition, the victim of the breach can also apply to the court for a civil-based claim, so that could result in the person being entitled to an award of damages, or the court at that stage might grant an interdict against the person to stop specified types of behaviour. So it's obviously important to underline to your client that they should report to the police if there are breaches, because the police keep a record of it, and it goes back to my point made at the outset that the police should always be their first port of call. So I wanted to talk a little bit about practical aspects for us as practitioners faced with either victims of domestic abuse or when acting for the alleged abuser. So I mentioned earlier about potentially sending a letter to the abuser, and sometimes when a client contacts me, that would be what I would advise in the first instance. But I weigh up with the client whether they feel they want to do that, or whether they feel that will aggravate the situation and put them at risk. If I am instructed to send a letter, then I'm basically just asking the person to desist the course of conduct, and pointing out that failure to do so will result in court proceedings and that they'll receive no further warning of those. But it can be obviously not something you could do in a case. Sometimes the abuse is so very bad, or it's so urgent, that you wouldn't think of sending out a letter, and indeed sending the letter might make it worse if they're still living under the same roof. You don't want to give the person a heads up that there's lawyers involved. Just on a housekeeping note, applying to court for protective orders or defending them is very front-loaded in terms of our work, and so that means it's expensive. So you need to make sure your legal aid cover is in place, and if it's a private fee-paying basis, then I would always get a payment to account before I start any work. I generally ask for £1,500, and my firm is very clear, particularly in the light of the pandemic, that we must always make sure we've got funds to account, just from a risk management perspective. To save on time, because it's so front-loaded, if you've got a new client who does consult you about domestic abuse and protective orders, dictate a precognition at the outset, which you can then update and easily turn into an affidavit. If for any reason you're also wanting to instruct counsel, then having a precognition will make it easier to get your papers off to counsel. I had a case last year where we were looking for protective orders, but just because of the nature of the case, we were raising in the court session for divorce proceedings. And it was very time pressed, and having that precognition was invaluable. You do want to reality test with your client. You need to check there's witnesses available who are willing to give evidence in court if required, either by affidavit or in person, or however the courts decide to do it due to COVID-19. If you have somebody who has no witnesses, and absolutely nobody, not even someone who maybe hasn't witnessed the behaviour but can speak to the effect of it on your client, that is a bit of a heads up that you need to be really careful. Most people will always have somebody that they can give you details for. Domestic abuse is something upsetting to talk about, particularly with a stranger, which we are to these clients at the outset. Sometimes they'll want to have a friend or relative present at the initial consultation for support, and that's completely fine. But important you say at the start that if that person is there during the consultation where you're giving advice, that person cannot also then be a witness in the person's case because they've been privy to advice tendered regarding the case itself. When you're at the stage of preparing your writ or your defences, ensure that your pleadings are clear and detailed, narration of incidents in date order, so it's easy to follow and paints a clear picture for the sheriff. So when I'm taking my client's statement, I try to get a detailed chronology of events which led up to the final incident or incidents which brought the client to me. In terms of how far back you go, it really does depend, but obviously the more recent, the more effective it is. As a rough rule of thumb, I tend to go back probably about a year, definitely 6 months. If it's a lengthy marriage, I might go for examples further back in time as well. And I want to identify key incidents. Again, there's not a hard and fast rule of thumb, but I would want at least, 2 or 3, and most of the cases I would normally have 5 or 6. You obviously are not pleading evidence, but you need to set out enough that you have a basis for what's in your affidavits, and worst case, if you have a proof on the matter. Sometimes I will ask my client to email me the detailed chronology. It saves cost for them because it's not my time taken up getting it from them. It means they can go and check diaries to be clearer about dates. For a lot of them, they've kind of already prepared details before they come. I notice clients are ever more prepared when they're coming to meetings, and it helps the client feel more in control of the process if they're the ones to do it. And obviously it's easier for us to put it into an affidavit because it's their words, and you'll maybe remember the practice note, fairly recent, not this year, can't remember when it was, I think it was last year, about affidavits and the need for it to be in the client's own words. So there's a benefit to getting your client to prepare it, but not all clients want to do that, so you might need to just take the statement yourself. You can't expect people to be completely accurate about dates. It's fine to say in or around September 2019, but you want it to be as specific as possible, because that gives you the best chance of persuading the court to get the order you're seeking. So it's that balancing act of be concise. You've got busy sheriffs, you want to make it easy for them to see what you're asking for, but also enough to justify the orders you're seeking. If the police have been involved, then get police incident numbers, police reports. If there's bail conditions in place, lodge a copy. If the client has spoken to their GP regarding the relationship or physical injuries or mental distress, try to get a doctor's report. Now, there will be a cost charged by the GP for that, and I have found that sometimes, or actually quite often, the GP practice will say, oh no, it'll take 2 or 3 weeks for Dr. such and such to do it. And in the most recent one I had where that was an issue, the client actually phoned herself and was able to get the report done sooner. But depending on the practice, it may be you draw a blank there, but it certainly would be a helpful thing to have. Affidavits from your client and witnesses will be required. As a good practice, I would always have that teed up. You might not have it for your pre-service hearing, but certainly for the hearing after service when the defender or his or her solicitor will be present, I would certainly want that because it adds weight to it. So definitely affidavits. Photos of injuries can be lodged, and they can be referred to in the person's affidavit. Just now, you'll be aware, due to COVID-19, there is an issue with notarising documents in person. We've got the Coronavirus Act 2020. We're notarising by video call, so we refer to that in the affidavit, and we record the notarisation to keep on our file. And I've put into the text of your talk the wording that we're using. Now, I don't want to put my neck on the line by saying that this is definitive and will definitely work, but certainly for 2 of my colleagues, they've had 2 cases where that wording has been okay. I also often will give clients information that might help them deal with the consequences of domestic abuse, and also, where relevant, ask if they've considered getting counselling for themselves. That's you have to play that one by ear. There are some clients that would just bridle up if you mentioned counselling. I've listed in your papers details of some support organisations. It's not obviously an exhaustive list, and you may well have your own ones that you can feed into that. So, with these sorts of orders, you will have a pre-service hearing, and different courts do these in different ways, and it's important you're familiar with your local court. So that's just something for you to find out for yourselves. Once you've got your pre-service hearing out the way and hopefully your interim order, you need your sheriff officers to serve the papers on the defender ASAP, because there'll be a hearing after service fixed. And that will be the biggie, if you like, in the case where you're trying to ensure that what you got at pre-service is kept in place, and maybe for some of what you're seeking to get it put in place at that hearing, because for some orders you might not get them at a pre-service. Like if you're applying for protective orders and as part of that you're maybe also asking for an interim residence order in relation to children, you wouldn't get that aspect of the pre-service hearing. So a lot of prep work for the hearing after service. If your client is the alleged abuser, then they may be concerned. They might come to you and say, split up from my partner, very worried, he's threatening to get the police on me, we're still living under the same roof, it's very difficult, he keeps recording me. You could consider lodging caveats so that you're alerted to a hearing. So that would be with the appropriate sheriff court for where parties are living, and the court session if it's relevant, if it's, for example, a high net worth or complicated case. If you're at the unfortunate stage where protective orders are already being sought against your client, you can consider whether it might be prudent for your client to offer an undertaking. So that would do away with the necessity for an opposed motion hearing with the uncertainty of outcome and attendant cost. So the undertaking could be to undertake not to come to the family home, or to vacate the family home within a set period of time and not to come back. And it could be recorded in an interlocutor to give the other party reassurance. I wouldn't offer to have it recorded when I'm saying to the other side about an undertaking, but if they've got their head switched on, then they probably would come back to say they want it recorded, because that gives them a bit more reassurance. Bear in mind that if an interdict has already been granted and by the time the client gets in touch with you, there's no chance of you fighting that part of it, you could argue there's no need for power of arrest to be attached if you can show there's been no further incidents since the interim interdict was granted. If the interdict is not going to prejudice your client, then I might be inclined to say to them, well, we say no to the power of arrest, but the interdict can continue, because obviously the cost of your client instructing you to get the interdict taken off is quite a lot, and they might not be successful. And then there's expenses and all of that aspect too. Where you're acting for the alleged abuser, try to get defences in before the hearing after service to set out your client's position in advance of the hearing. Not always possible to do that due to time constraints and depending on when the client first instructs you, but it's helpful because it sets out your client's stall, and hopefully the sheriff or judge will look at it before the hearing. As ever, be concise but comprehensive. Of course, it's about ensuring you've got detailed submissions as well, and possibly affidavits to counter what's being said about your client. It's fair to say that if protective orders are granted and if there's children under 16, it will inevitably make it harder for your client to get contact back on track. The other party may argue Section 11 7B and 7C of the Children's Scotland Act 1995. So that's the section where the sheriff, in deciding whether to make a Section 11 order, so that's an order regulating contact, amongst other things, regard shall be had to the need to protect the child from any abuse or the risk of any abuse which affects or might affect the child, the effect such abuse or the risk of such abuse might have on the child, the ability of a person who has carried out abuse which affects or might affect the child to meet the needs of the child. And Section 11(7)(c) makes clear abuse includes domestic abuse, and that it can be abuse of a person other than the child, for example the primary carer, who might be or who would be the pursuer in the actions for the action for the protective orders. It's fair to say that sometimes when a relationship is in the throes of breaking down, one or other party behaves in a way that's completely out of character and which leads to a conviction. For example, under Section 38, I see I've got a typo in my notes, of the 2010 Act. Now, I'm not saying that to try to condone behaviour, but if I were acting for that person, I would argue that an isolated incident such as that should not be used as a stick to prevent that person having contact with their child, because although, to put it bluntly, the parties hate one another and are clearly completely unsuited to one another, that doesn't mean that the person is a bad parent. Now obviously if I'm on the other side, I'm not saying that, but it's just important to look at it in the round and depending on who you're acting for. Even if contact has to start off on a supervised basis, so long as I can show that contact goes well, hopefully I can start to build it back up for my client. And sometimes that involves me having to do a wee bit of reality checking with my client. That they often will be really upset at the notion of supervised contact, and rightly so for a parent who's been very involved in their child's life. But I try to sell it to them by saying this is a staged process and you've got a long-term goal here, and we need to see it in bite-sized chunks, and usually that helps with most clients. Sometimes the protective order can have a real impact on the person against whom the order was made, and in those situations we might require to have a proof on the matter. Now, I had one last year that was looking as though it was going to have to go down that road. So kinds of situations where that might occur would be if two people were running a business together and one obtains an interdict which prevents the other from entering the premises. That would then fetter that person's ability to manage the business and in turn the income from it and their livelihood. Or if it's detrimentally impacting on your client's ability to have contact with the child of the relationship. Obviously, you need to think really carefully about taking this sort of thing to a proof, though, because of the huge cost involved. If it's private fee-paying basis client. So, yeah, the client has to do that cost-benefit analysis there. So, in conclusion, whoever we act for, whether it's the victim or the alleged abuser, it calls for sensitive and tactful handling on our part, as well as the ability to prepare court documentation quickly but comprehensively. Getting the right protection in place means exercising our judgment to ensure we get the best outcome possible for our client. It's also about protecting ourselves, though, because dealing with these kinds of cases, particularly if you do a lot of them, I started off working in Clydebank and I did a lot of protective order work. It's quite harrowing, quite draining, sometimes a bit dispiriting when you see people who you've maybe helped get orders and they've reconciled and then it happens again and they come back to you. So you just as a sort of aside to the rest of my talk, you need to look out for yourselves as well and make sure you're not taking on too much. And it's stressful where you're having to prepare pleadings and recognitions very quickly. I realise that for a lot of you potentially won't be doing the pleadings part of it yourselves for the solicitors, but I know that a lot of you as paralegals do a lot of the work involved. with these kinds of protective orders just because it is so front loaded and it's all hands to the deck. Anyway, I do hope this has been helpful, and please, if you've got queries, then just get in touch with me. Okay, thank you.